Section 32 to Section 38. In BNS, equivalent provisions are Section 3.4 to Section 3.9 of BNS. In certain circumstances, an entire act is attributed to a person who may have performed only a fractional part of it. If you divide a criminal act into parts, in certain circumstances, if a person has done only a part of the act, then also the entire act will be attributed to him. That is the thing. Actually, the joint liability is there in Section 32 to 38. In Section 32 to 38, the provisions say if the criminal offense the act will be put into parts. Then also, if a person does only a part of the act, then in certain circumstances, the entire act may be attributed to that particular person. The answer is B. All about intention is true except one. It is a state of mind. It is an objective element. It is a state of mind, it is true. It is an objective element. No, it is absolutely wrong. It is a subjective element. It comes within the mind. Rarely susceptible to proof. That is also true. Always a matter of inference. That is also true. Because from the action we will infer criminal intent. That's why A, C and D are correct. But B is wrong. It is an objective element. It is not an objective element. It is subjective element. The word illegal is applicable to everything which is an offense, which is prohibited by law, which furnishes ground for civil action, and all of them. The answer is D. We have already explained about this thing. Which of the following is true of intent of defraud? A general intention to defraud. Actually, we will see the definition. It is Section 2.9. Fraudulently means doing anything with the intention to defraud, but not otherwise. If the intention is only to do fraud, then doing anything is fraudulently. Which of the following is true of intent of defraud? A general intention to defraud without the intention of causing wrongful gain to one person or wrongful loss to another. Yes. To prove intention of defraud, it is not at all necessary that there should have been some persons defrauded or who possibly might have been defrauded by this act. It is also true. The word defraud is of double meaning. That is also true. That's why the answer is D. The word document as per Section 29 of IPC includes any matter expressed or described upon by any substance. In BNS, under Section 2.8, document has been defined and various illustrations have been given. That shows this definition is very important. Section 2.8 document means any matter expressed or described upon any substance by means of letters, figures, or marks, and includes electronic and digital record intended to be used or which may be used. There must be intention or which may be used as evidence of that matter. It may be brought as evidence. This document may be brought as an evidence in the court of law, whether it is intended or not, or it has been used. Document means any letters, not just letters, any figures or marks upon any substance. It may be on the paper, on the leaf, on a stone, on a tree trunk, anything. Explanation. It is immaterial by what means upon or upon what substance the letters, figures, or marks are formed, or whether the evidence is intended for or may be used in court or not. Here, I have already told immaterial or what substance. It doesn't prescribe that only on the papers only document has to be created. It can be created on anything. If on a cigarette packet, if you write a will, then also it is a document. Now, a writing expressing the terms of contract, which may be used as evidence of the contract, is a document. Example, contract is a document. A check upon a banker is a document. Examples you remember because directly the questions will come from these examples. A power of attorney is a document. A map or plan which is intended to be used or which may be used as evidence is a document. A writing containing directions or instructions is also a document. For example, in criminal offenses, before committing the criminal offense, accused or his accomplice make a rexy investigating the crime spot, how to do a crime. Before formulating a modus operandi of a crime, they will do a rexy. After doing a rexy on a paper, they will draw where they have to bring the vehicle, where they have to park it, from which door they have to enter the building, and all these things. Such kind of things. A map or plan which is intended to be used or which may be used as evidence is a document. A writing containing directions or instructions is also a document. You remember these 5 examples because these 5 examples will directly come into the examination. Explanation 2. Whatever is expressed by means of letters, figures, or marks, as explained by mercantile or other usage, shall be deemed to be expressed by such letters, figures, or marks within the meaning of this section, although the same may not be actually expressed. Generally, people have got certain usages, but in commercial transactions, they have got their different usages. They have got their different signals. For example, in the stock market, we will see they show some fingers and other things that indicate the value of a stock. They have got that usage. Here example has been given. If in the commercial transaction that usage is there, that has to be understood. A writes his name on the back of a bill of exchange payable to his order. The meaning of the endorsement, as explained by mercantile usage, is that the bill is to be paid to the holder. The endorsement is a document and shall be construed in the same manner as if the words pay to the holder or words to that effect had been written over the signature. For example, we go to a bank and hand over a check and they ask the holder of the check to sign on the reverse side of the bill. Actually, the owner of the check will put his signature at the back of the check. That means he is giving authority to the holder of the check to go and encash that check. That is the usage. That is the mercantile bank mercantile usage. To put a signature behind the check or a bill of exchange means you are giving the authority to the bank to give authority to the bank to pay to the holder of the check the amount. Now we will be coming here. The word document as per section 29 of IPC includes any matter expressed or described upon by any substance by means of letters, figures, or marks only, by more than one of those means intended to be used or which may be used as evidence of that matter. Both A and B. Yes, both A and B are correct. Which of the following can be called a document as per section 29 of IPC? You have to remember section 2.8 of the document also. Under BNS, it is section 2.8. Banker's check, it has come. Power of attorney, it has come as an example. Map, it has come. All of them, the correct answer is D. In the illustrations, all these things have come. Which of the following conditions are necessary to fulfill the requirements of Section 34 of Indian Penal Code? You see how many times Section 34 is coming. That means Section 3.5 of BNS. It is a very important section. You have to remember these things. Also, landmark judgments under Section 34. The person must be present on the scene of occurrence. Which of the following conditions are necessary to fulfill the requirements of Section 34? The person must be present on the scene of occurrence. There must be a prior consent or a pre-arranged plan, either A or B, both A and B. The answer is given D. That means the person must be present on the scene of occurrence. It is also correct. There must be prior consent of a pre-arranged plan. But as per the Supreme Court decisions under Section 34 of IPC or Section 3.5 of BNS, person's presence is not essential requirement under Section 34 IPC. This thing has been held in Tukaram versus State of Maharashtra in 1979 case. The court held that even though a person may not be actually at the site of the occurrence, then also Section 34 addressed. Earlier to that, in 1960, again Supreme Court in J.M. Desai versus State held the same opinion that accused that the person on whom Section 34 is invoked is not required to be present at the site of occurrence. But here, for the purpose of examination, we write A and B because it's the exemption case. Which of the following creates a new offense? You know the answer. Section 34 of the IPC, no. Section 35 and Section 36 of the IPC, no. These are joint liabilities. These are parts of Section 34. Section 37 of the IPC, this is also not there, none of them. These are common liability cases, and here new offense has not been created. It is only rule of evidence. That's why the correct answer is D. Say 63. A jailer, it is a very important question. A jailer has the charge of judge, a prisoner. A intending to cause Jud's death illegally omits to supply Jud with food, in consequence of which Jud is much reduced in strength, but the starvation is not sufficient to cause his death. It is important. Jud is much reduced in strength due to starvation, but it is not sufficient to cause his death. A is dismissed from his services. B succeeds him. Now B has become a jailer. B without collusion with A. Again, it is important. He has not colluded with A, but he has also intended to kill Jed. Illegally omits to supply Jed with food. Illegally, he doesn't provide food to Jed, knowing that he is likely thereby to cause Jed's death. He has got the knowledge that if he does not provide food, B has got the knowledge that if he does not provide food to Jed, who is already starving, death may be caused. Knowing that he is likely thereby to cause Jed's death. Finally, Jed died. Which of the following judgment applies to both A and B under section 37 of the IPC? It is common liability. Jed has died. There is this Jed's death can be divided into two parts. One part is caused by A and the second part is caused by B. Here, A is only guilty of an attempt to commit a murder, while B is guilty of murder. It is a correct answer because while A left Jed, he did not die. It is not sufficient to cause his death. That means it is only attempt to commit murder. Nothing more than that. But in the case of B, it is murder. A is the correct answer. Here we see what BNS is saying. BNS section 2, subsection 8, section 3. Section 3, subsection 8 says, when an offense is committed by means of several acts, whoever intentionally cooperates in the commission of that offense by doing any one of these acts, either singly or jointly with any other person, commits that offense. A jailer has the charge of judge, a prisoner A intending to cause just legal events. The same thing. Here, B is guilty of murder, but as A did not cooperate with B, here cooperation is not there. A is guilty only of an attempt to commit murder. That's why the answer is here. It has been given in the illustration itself. That's why you read illustrations in BNS very thoroughly because from illustrations itself, the answers will come. Next, 64. The act voluntarily done in effect and substance in section 39 IPC means. The act voluntarily done in effect and substance in section 39 IPC means. What is section 39? Section 39 is voluntary. What is the meaning of voluntary? Voluntary has been defined in section 233. A person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it, or by means which at the time of employing those means he knew or had reason to believe to be likely to cause it. Here illustration is very, very important. A sets fire by night to an inhabited house in a large town for the purpose of facilitating a robbery and thus causes the death of a person. Here, A may not have intended to cause death and may even be sorry that the death has been caused by this act. Yet, if he knew that he was likely to cause death, he has caused death voluntarily. Voluntarily means out of his own free will. There is no force. Here, A sets the fire. His intention is to rob that inhabited house. He knows that it is an inhabited house. There people are living. Even then, to rob that house, he sets the fire. That's why death has been caused. Even though he doesn't intend to cause the death of any person, as death has been happened, voluntarily he has caused the death. We have to understand it like this. The act done intentionally, the act done with the knowledge of end result being a crime, Act done when the doer has a reason to believe that the actor's use would be an offense. All these things will be coming in the voluntary action. The accused attacked the victim with a spear and others inflicted blows on legs and arms with lathis. Only those accused who used lathis are guilty. Only the accused who used the spear is guilty. Each accused must be convicted for the offense of which he is actually found to be guilty. The correct answer is C. Because if several actions have been done, each action can be separated from the other action. Then the accused will be attributed to the offense, actual offense which he has committed. There, accused attacked with a spear, and some other accused inflicted blows on legs and arms with the lathis. That's why each and every one will be attributable to the offense which he has committed. It is the final question. Under section 44 of IPC, the term injury means, it is a very important thing. Injury means, it is section 2, subsection 14. Injury means any harm, whatever, illegally caused to any person in body, mind, reputation, or property. Illegally caused to a person, body, mind, reputation, or property. Answer is C. All the four elements are there. In other options, all the four elements are not there. That's why the correct answer is C. Now, with this, we have completed the multiple choice questions. Thank you very much for a patient hearing.